Good evening, beautiful people. Thank you so much for joining us this evening. Hope you're having a fantastic day and a fantastic week. Welcome to our live weekly YouTube, yes, YouTube readings of the final report of the California Reparations Task Force right here on the CJEC YouTube channel. Give it up for the CJEC YouTube channel. Yes, CJEC is on YouTube, and this is the only live readings of the California Reparations Task Force's final report on YouTube. The final report of the first in the nation Reparations Task Force is one of, if not the most important government reports about the Black American community since the 1960s, let's say. Equally important, though, it is also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing you every single page of it, chapter by chapter, every week on Thursdays at 7 p.m. Pacific Standard Time, so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report of the California Reparations Task Force is presented to you, you, as a community service with support, of course, from the reparations organizing and mobilizing team at the Coalition for a Just and Equitable California, CJEC. We are CJEC, California's leading reparations organization, born for reparations, of course, and reparative justice for Black American freedmen living in our great state of California. For more info on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. chattel slavery, the Act to End Current Slavery in California state prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Okay, before we go any further, right now, I need you, yes, again, you, to do three things. First, like this video. Second, hit the bell for reminders. And third, subscribe. That's three, right? Third, subscribe to our channel. Do those three things for me right now. Like this video, hit the bell for reminders, and subscribe to our channel. After we're done reading tonight, I need you to do three more things. Hey, I'm an organizer. We ask people to do stuff. That's what organizers do. So after we're done reading tonight, I need you to do three more things. Mo things. Get connected. Follow CJEC on social media. That's Instagram, TikTok, Facebook, and Twitter at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and info on our Get Involved page. And finally, get involved. Support our work by volunteering and or donating. To donate, just click the donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. By way of introduction, my name is Chris. I live in Sacramento, California. I'm from New York City, and I am a volunteer reparations advocate with CJEC's reparations organizing and mobilizing team. By way of housekeeping, if during tonight's reading the live stream gets cut out for any reason at all, we will restart the stream and pick up right where we left off. The agenda for today, chapter 14 of the final report of the California Reparations Task Force. The title of the chapter we're reading tonight, International Reparations Framework. So before I go any further, actually, just a quick note about why we're starting on chapter 14 of the final report and not chapter 1 of the final report. Many of you, but maybe not all of you, will know that we actually read every single chapter of the first report of the California Reparations Task Force last year on Twitter Spaces. Shout out to Twitter Spaces. And during those readings, we read about a chapter or so every single week, and up to all 13 chapters of that first report that the California Reparations Task Force put out. Well, it just so happens that that entire first report is the first half of the final report. So we're starting with the new stuff. We're starting with the stuff that we haven't read, but we will end up, when we're done, reading the entire final report. We're just going to start with the second half because we've read the first half already. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website, www.cjec-official.org/reports. Okay, we're about ready to start our reading, but before we do, I have some special thanks and some special announcements to make. First, as always, I'd like to thank our good friends at ETM Media Group on YouTube for their live readings of the first report of the California Reparations Task Force. You can watch their readings of the first report of the Reparations Task Force on their channel at ETM Media Group here on YouTube, and also on our website at www.cjec-official.org/videos. Second, for those of you who don't know, historic reparations legislation in California is here, and more is coming. SB 490, that's Senate Bill 490, is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. And this bill was introduced very, very recently by State Senator Stephen Bradford and will move forward in 2024. To read the bill, go to our website, www.cjec-official.org/advocacy. Third, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During the 2024 legislative session in California, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass bills for reparations in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, yes, when those bills are passed, not if, but when, we need our governor to sign the bill. So to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Lastly, but not least, special thanks to CJEC's reparations organizing and mobilizing team, specifically our volunteer final report readers. And without further ado, Chapter 14 of the final report of the California Reparations Task Force. Chapter 14, International Reparations Framework. Introduction. AB 3121, that's Assembly Bill 3121, required the recommendations from the Reparations Task Force to, quote, comport with international standards of remedy for wrongs and injuries caused by the state that include full reparations and special measures as understood by various relevant international protocols, laws, and findings. Therefore, this chapter lays out the international legal framework for reparations created in December 2005 by the United Nations General Assembly, UNGA, in Adopted Resolution 60-147. Going forward, the UNGA framework shall be referred to as the, quote, UN Principles on Reparation, end quote. In the UN Principles on Reparations, The UNGA held that any full and effective reparations scheme must include the following 5 forms. 1. Restitution. 2. Compensation. 3. Rehabilitation. 4. Satisfaction. And 5. Guarantees of non-repetition. While the UN principles on reparation are primarily based on the notion of state responsibility, the negotiators also reached a consensus that, quote, non-state actors are to be held responsible for their policies and practices, allowing victims to seek redress and reparation on the basis of legal liability and human solidarity, and not just on the basis of state responsibility, end quote. This can be found in Principle 3C, which provides for equal and effective access to justice. Quote, irrespective of who may ultimately be the bearer of responsibility for the violation, end quote. Additionally, Principle 15 states, quote, in cases where a person, a legal person, or other entity is found liable for reparation to a victim, such party should provide reparation to the victim or compensate the state if the state has already provided reparation for the victim, end quote. This means that the funding, among other remedies for reparations, may come not only from the state of California, but also from non-state actors who help perpetuate the hardships against enslaved persons and we, their descendants. 2. International legal framework for reparations. Overview. This section sets forth the legal framework for reparations under international law, specifically the UN principles on reparation, quote, basic principles and guidelines on the right to a remedy and reparation for victims of gross human rights violations of international human rights law and serious violations of international humanitarian law, end quote. Who qualifies for reparations under the UN principles on reparation? According to the international legal framework laid out by the UN principles on reparation, victims of gross violations of international human rights law and serious violations of international humanitarian law should be provided with full and effective reparations. The UN principles on reparation define victims as, quote, persons who individually or collectively suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts of omission that constitute gross violations of international human rights law. Furthermore, the, quote, term victim also includes the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization, end quote. Additionally, quote, a person shall be considered a victim regardless of whether the perpetrator of the violation is identified, apprehended, prosecuted, or convicted, and regardless of the familial relationship between the perpetrator and the victim, end quote. In its 2018 Practitioner's Guide on the, quote, right to a remedy and reparation for gross human rights violations, end quote, the International Commission on Jurists, the ICJ, highlighted that the word victim, quote unquote, has many different meanings across international human rights systems. However, the ICJ specified that for purposes of the UN principles on reparation, the definition of, quote, victim, end quote, was meant to be broad. According to the ICJ, a, quote, victim is not only the person who was the direct target of the violation, but any person affected by it directly or indirectly, end quote. The ICJ cited how certain authorities, quote, disfavor the distinction between direct and indirect victims, end quote. So, quote, reparations programs should use a wide and comprehensive definition of victim and should not distinguish between direct and indirect victims, end quote. A comprehensive definition of the word victim should include family members who have endured, quote, unique forms of suffering as a direct result, end quote, of what happened to their loved ones. A lot of quotes and end quotes. So what constitutes gross violations of international human rights law and serious violations of international humanitarian law under the UN principles on reparation. Well, while the UN principles on reparation did not formally define either, quote, gross violations of international human rights law, end quote, or, quote, serious violations of international humanitarian law, end quote, the ICJ elucidated the definitions of these terms. Specifically, the ICJ defined, quote, gross violations and serious violations, end quote, as collectively as the types of violations that affect the types of violations that affect in qualitative and quantitative terms the most basic human rights of human beings, notably the right to life and the right to physical and moral integrity of the human person. The ICJ's examples of gross and serious violations include, quote, genocide, slavery and slave trading, murder, enforced disappearances, torture, or other cruel, inhuman, or degrading treatment or punishment, prolonged arbitrary detention, deportation or forcible transfer of a population, and systematic racial discrimination, end quote. The ICJ also held that, quote, harm should be presumed in cases of gross human rights violations. So, what are victims' rights to remedies under the UN principles on reparation? Victims of gross human rights, international rights law, and serious violations of international humanitarian law are entitled to certain remedies under international law. A, equal and effective access to justice. B, adequate, effective, and prompt reparation for harm suffered. C, access to relevant information concerning violations and reparation mechanisms. According to the UN Human Rights Committee, the right to an effective remedy necessarily entails the right to reparation. An effective remedy refers to procedural remedies, whereas the right to reparation refers to restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. In short, victims are entitled to have effective procedural remedies available to them, which will in turn help them receive the reparations to which they are entitled. To provide effective access to justice, a state must, quote, establish functioning courts of law or other tribunals presided over by independent, impartial, and competent individuals exercising judicial functions, end quote, and have, quote, competent authorities to enforce the law and any such remedies that are granted by the courts and tribunals, end quote. So, what must full and effective reparations include under the UN principles on reparation? According to the international legal framework laid out by the UN principles on reparation, full and effective reparations must include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Restitution. Quote, restitution should, whenever possible, restore the victim to the original situation before the gross violations of international human rights or serious violations of international humanitarian law occurred. Restitution includes, as appropriate, restoration of liberty, enjoyment of human rights, identity, family life, and citizenship, return to one's place of residence, restoration of employment, and return of property, end quote. According to the ICJ's interpretation of the UN principles on reparation, where a state can return a victim to the status quo, the state has, quote, an obligation to ensure measures for its restoration. However, even though restitution is considered the primary form of reparation, the ICJ acknowledges that, quote, in practice, restitution is the least frequent because it is mostly impossible to completely return a victim to the situation they were in before the violation, especially because of the moral damage caused to victims and their relatives, end quote. So the ICJ holds that where complete restitution is not possible, as will often be the case, the state must, quote, take measures to achieve a status as approximate as possible, end quote. Compensation. Quote, compensation should be provided for any economically accessible damage as appropriate and proportional to the gravity of the violation and the circumstances of each case, resulting from gross violations of international human rights law and serious violations of international humanitarian law, such as physical or mental harm, lost opportunities, including employment, education, and social benefits, material damages and loss of earnings, including loss of earnings potential, moral damage, costs required for legal or expert assistance, medicine and medical services, and psychological and social services. According to the ICJ's interpretation of the UN principles on reparation, compensation is the quote specific form of reparation seeking to provide economic or monetary awards for certain losses, be they material or immaterial, or pecuniary or non-pecuniary in nature, end quote. The ICJ highlighted compensation previously awarded by claims commissions for cases with claims of, quote, material and immaterial damage, end quote, and especially for cases with claims of, quote, wrongful death or deprivation of liberty, end quote. The United Nations recognized a right to compensation, quote, even where it is not explicitly mentioned in a particular treaty, and the Human Rights Committee, quote, recommends as a matter of practice that states should award compensation, end quote, for state-sanctioned harms, of course, based on the International Covenant on Civil and Political Rights. It is important to note that international jurisprudence divides compensation into two categories, quote, material damages, end quote, and quote, moral damages, end quote. Material damages include, among other things, loss of actual or future earnings, loss of movable or immovable property, and legal costs. Per the UN principles on reparation, any reparation proposal involving compensation for material damages must cover, quote, lost opportunities, including employment, education, and social benefits, end quote. Additionally, according to the European Court on Human Rights, in order for a victim to receive compensation, quote, there generally must be a clear and causal connection between the damage claimed by the applicant and the violation, end quote. However, quote, as far as existence of material damage can be demonstrated, the award does not depend on whether the victim can give detailed evidence of the precise amounts, as it is frequently impossible to prove such exact figures, end quote. Therefore, in the likely event that a victim lacks detailed information, quote, compensation ought to be granted on the base of equity, end quote, as long as there is a causal link between the violation and the damage. Per the UN principles on reparation, any reparation proposal involving compensation for moral damages must, quote, encompass financial reparation for physical or mental suffering, end quote. Since this type of damage is not economically quantifiable in most cases, the assessment must be made in equity. Furthermore, quote, since it is difficult to provide evidence for certain moral or psychological effects of violations, mental harm should always be presumed as a consequence of gross violations of human rights. Finally, quote, for persons other than close relatives, harm may have to be shown so as to limit the number of persons who may claim compensation, end quote. But the conditions for claiming compensation should not be impossible to meet. Rehabilitation. Quote, rehabilitation should include medical and psychological care as well as legal and social services, end quote. According to the ICJ's interpretation of the UN principles on reparation, victims are entitled to rehabilitation of their dignity, their social situation, and their legal situation, and their vocational situation. Relying on the Convention Against Torture's assessment of rehabilitation, the ICJ also provided, quote, rehabilitation must be specific to the victim based on an independent, holistic, and professional evaluation of the individual's needs, and ensure that the victim participates in the choice of service providers. Furthermore, quote, the obligation to provide the means for a full rehabilitation as full rehabilitation as possible, may not be postponed and does not depend on the available resources of the state, end quote. Finally, rehabilitation should include a wide range of interdisciplinary services, such as medical services and psychological care, as well as legal rectification of criminal records or invalidation of unlawful convictions, and social services, community and family-oriented assistance and services, vocational training, and education. Satisfaction. Quote, satisfaction should include, where applicable, any or all of the following: effective measures aimed at the cessation of continuing violations, verification of the facts and full and public disclosure of the truth to the extent that disclosure does not cause further harm or threaten the safety and interests of the victim, the victim's relatives, witnesses, or persons who have intervened to assist the victim or prevent the occurrence of future violations. The search for the whereabouts of the disappeared, for the identities of the children abducted, and for the bodies of those killed, and assistance in the recovery, identification, and reburial of the bodies in accordance with the expressed or presumed wish of the victims or the cultural practices of the families and communities. An official declaration or a judicial decision restoring the dignity, the reputation, and the rights of the victim and of persons closely connected with the victim. Public apology, including an acknowledgement of the facts and acceptance of responsibility. Judicial and administrative sanctions against persons liable for the violations. Commemorations and tributes to the victims. Inclusion of an accurate account of the violations that occurred in international human rights law and international humanitarian law training and education material at all levels. According to the ICJ's interpretation of the UN's principles on reparations, satisfaction is a, quote, non-financial form of reparation for moral damage or damage to the dignity or reputation, and can, in the form of a condemnatory judgment, the acknowledgement of truth, or the acknowledgement of responsibility and fault. Satisfaction includes, quote, the punishment of the authors of the violation. Furthermore, the UN updated principles on impunity recommend that the final report of truth commissions be made public in full. This is supported by the UN Human Rights Commission's resolution on impunity, which recognizes that for the victims of human rights violations, public knowledge of their suffering and the truths about their perpetrators, including the accomplices of these violations, are essential steps towards rehabilitation and reconciliation. Another important factor when it comes to satisfaction is a public apology as well as a public commemoration. The public apology is to help in, quote, restoring the honor, reputation, or dignity of a victim, end quote. The public commemoration is, quote, particularly important in cases of violations of the rights of groups or a high number of persons, sometimes not individually identified, or in cases of violations that occurred a long time in the past, end quote. A public commemoration in these cases has a symbolic value and constitutes a measure of reparations for current but also future generations. Guarantees of non-repetition. Quote, guarantees of non-repetition should include, where applicable, any or all of the following measures which will also contribute to prevention: ensuring effective civilian control of military and security forces, ensuring that all civilian and military proceedings abide by international standards of due process, fairness, and impartiality, strengthening the independence of the judiciary, protecting persons in the legal, medical, and healthcare professions, the media, and other related professions and human rights defenders, providing on a priority and continued basis human rights and international human law education to all sectors of society and training for law enforcement officials as well as military and security forces, promoting the observance of codes of conduct and ethical norms, in particular international standards, by public servants, including law enforcement, correctional, media, medical, psychological, social service, and military personnel, as well as by economic enterprises, promoting mechanisms for preventing and monitoring social conflicts and their resolution, and reviewing and reforming laws contributing to or allowing gross violations of international human rights law and serious violations of international humanitarian law. According to the ICJ's interpretation of the UN Principles on Reparation, the guarantee of non-repetition derives from general international law. A guarantee of non-repetition is an aspect of, quote, restoration and repair of the legal relationship affected by the breach, end quote. According to the International Law Commission, assurances and guarantees are concerned with the restoration of confidence in a continuing relationship. Guarantees of non-repetition overlap with international human rights law because, quote, states have a duty to prevent human rights violations, end quote. A guarantee of non-repetition is required expressly as part of the legal consequences of a state's decisions or judgments. This express requirement is supported by the UN Commission on Human Rights, the Human Rights Committee, the Inter-American Court and Commission on Human Rights, the Committee of Ministers and Parliamentary Assembly of the Council of Europe, and the African Commission on Human and People's Rights. Another measure that falls under the guarantee of non-repetition is, quote, the necessity to remove officials implicated in gross human rights violations from office, end quote. Finally, a guarantee of non-repetition can and often must involve structural changes that must be achieved through legislative measures and to ensure that the violation cannot not ever happen again. International and national genocide framework. The term, quote, genocide was first coined by Raphael Lemkin, a Polish jurist who advocated for legal protections for ethnic, religious, and social groups in his 1944 book, Axis Rule in Occupied Europe. Lemkin wrote, quote, by genocide, we mean the destruction of a nation or of an ethnic group. Generally speaking, genocide does not necessarily mean the immediate destruction of a nation, except when accomplished by mass killings of all members of a nation. It is intended rather to signify a coordinated plan of different actions aiming at the destruction of essential foundations of life of national groups with the aim of annihilating the groups themselves. Genocide is directed against the national group as an entity, and the actions involved are directed against individuals, not in their individual capacity, but as members of the national group. Lemkin argued for international law to recognize genocide as a crime, and in 1948, the United Nations General Assembly passed the Convention on the Prevention and Punishment of Crimes of Genocide, or the Genocide Convention. The Genocide Convention has since been ratified by 153 states. As the UN, or United Nations, has noted, the popular understanding of what constitutes genocide tends to be broader than it is legally defined. The Genocide Convention decides genocide with a mental element and a physical element. For the mental element, a perpetrator must have the intent to destroy in whole or in part a national, ethnic, racial, or religious group. The physical element is described by the act of killing or causing serious bodily or mental harm. The imposition of measures intended to prevent births within such group, the deliberate inflicting of conditions of life calculated to bring about that group's physical destruction, or the forcible transferring of children of the group to another group. The Genocide Convention does not specify a punishment for genocide, only that persons charged with genocide, quote, shall be tried by a competent tribunal of the state in the territory of which the act was committed, end quote, or by an international tribunal with jurisdiction over the territory. The 1948 Genocide Convention takes the position that, quote, cultural destruction does not suffice, nor does an intention to simply disperse a group as genocide. Prior to the passage of the Genocide Convention, the United Nations had passed a resolution defining the crime of genocide as a, quote, denial of the right to existence of entire human groups, end quote, with no mention of interest. After intense political brokering by the United States of officials who feared being accused of genocide for the United States treatment of African Americans, and for government officials' involvement in the lynchings and participation in the Ku Klux Klan, the 1948 Genocide Convention was adopted without mention of cultural destruction and with the added mental element requiring demonstration of intent. Although then President Harry Truman's administration supported the Genocide Convention during its development in the United Nations, it encountered strong resistance in Congress and among academics over concerns of domestic sovereignty. A representative of the American Bar Association criticized the convention on the grounds that it could be used to classify attacks on individual African Americans as, quote, genocide. As a result, the Genocide Convention was not ratified during Truman's term. The next administration, under President Dwight Eisenhower, withdrew executive branch support for the convention for domestic political reasons. Presidents John F. Kennedy and Lyndon Johnson took no action to reverse course. And when President Richard Nixon endorsed ratification, Senate hearing witnesses again raised warnings that the convention could expose the United States to foreign judgment on racial issues and on America's military behavior in Vietnam. Finally, under President Ronald Reagan, nearly 40 years after the UN approved the Genocide Convention, the United States implemented legislation to ratify the convention with the Genocide Convention Implementation Act of 1987, or the Genocide Act, becoming the 98th nation to do so. The Genocide Act added the crime of genocide to the federal criminal code, but with a more heightened intent requirement than is found in the Genocide Convention. Under the Genocide Act, the offense of genocide is committed when an individual with the, quote, specific intent to destroy in whole or in substantial part a national, ethnic, racial, or religious group, kills members of that group, causes serious bodily harm, bodily injury, or permanent mental impairment through drugs, torture, or similar techniques to members of that group, imposes measures intended to prevent births within the group, subjects members of the group to conditions of life that are intended to cause the physical destruction of the group, or forcibly transfers children of the group to another group. To be covered by the statute, the offense must be committed within the United States or be committed by a person who is a citizen or permanent resident of the United States, a stateless person whose habitual residence is in the United States or present in the United States. A person who attempts or conspires to commit the offense of genocide faces the same punishment as one who completes the offense. Genocide scholars have developed other frameworks outside of the narrow legal frameworks of the Genocide Convention and the Genocide Act. For example, in his early writings on genocide, Lemkin viewed genocide as a process rather than an event that involved, quote, one destruction of the national pattern of the oppressed groups, the other the imposition of the national pattern of the oppressor, end quote, a view that encompasses structural genocide. Since the 1960s, scholars have developed the conception of genocide as encompassing structural and institutional violence. This type of violence can include discrimination by institutions, the globalization of food systems that lead to poverty and starvation, and the effects of internal colonialism by government institutions on indigenous populations. Cultural genocide, known as ethnocide, also derived from Lemkin's early writings, encompasses the destruction of a group's cultural, linguistic, and existential underpinnings without necessarily killing members of the group, end quote. So, applicability to African Americans. When the acts perpetrated upon African Americans have been committed with the intent to destroy them, in whole or in part as a group, African Americans have been victims of genocide, as the Genocide Convention defines that term. While the intent requirement is understood to be more difficult of an element of genocide to prove, a number of scholars regard the acts committed by the United States federal government, state, and local governments and its citizens against African Americans from enslavement onward as constituting genocide under the convention. When alternate frameworks for understanding genocide are employed, There is less room for debate that genocidal acts have been committed against African Americans in the United States. African Americans for centuries have suffered harms and atrocities inflicted on the basis of race and without regard for their humanity. Slavery inflicted death and serious bodily and mental harms. And the trafficking of enslaved people caused the quote forcible transfers of children from their families to plantations unknown. The Ku Klux Klan, or KKK, and others committed innumerable lynchings and systematically visited racial terror against African Americans, killing and causing serious bodily harm while government officials participated or turned a blind eye. By 1931, at least 30 states had passed eugenics laws that deliberately targeted African Americans for involuntary sterilization and imposition of, quote, measures intended to prevent birth. Acts against African Americans that constitute genocide when committed with the requisite intent continued after the United States ratified the Genocide Convention. Well, to this day, the American legal system continues to over-police African American communities, disproportionately kill and commit acts of violence against African Americans, and disproportionately imprison and execute African Americans, causing serious physical and mental impairment and having the effect of separating families and preventing births. Although the last recorded lynching in the United States was in 1981, the civil rights organization Julian has identified at least 8 suspected lynchings in Mississippi alone since 2000. 7 of these deaths were by hanging, and each ruled as a suicide by law enforcement, despite suspicious circumstances. The other was a racially motivated beating of an African American man by a group of 10 white teenagers. Academics have also identified the involuntary sterilization of African American women through welfare incentive programs in the 1990s as an example of a violation of the Genocide Convention, specifically its prohibition against the systematic elimination of specific populations. The framing of the United States treatment of African Americans as genocide is not new. Even before the Genocide Convention in 1946, the National Negro Congress delivered an 8-page petition to the UN Secretary General, asking him to take action to address the subjugation of African Americans, particularly in the South, where 10 million Black people lived in deplorable conditions. Although the UN declined to act, the 1946 petition successfully drew attention to the plight of African Americans. Further, on October 23, 1947, in order to spur the United States government's slow pace of racial reform, the NAACP, led by W.E.B. Du Bois, presented UN officials with a 95-page, quote, appeal to the world, intended as an improvement on the 1946 petition. Du Bois framed the petition as a, quote, frank and earnest appeal to all the world for elemental justice against the treatment which the United States has visited upon African Americans for 3 centuries at that time. The detailed 1947 petition lambasted the United States for denying a host of human rights to its African American minority population and garnered much more attention than the previous 1946 petition. Du Bois sought support from First Lady Eleanor Roosevelt, a member of the American delegation to the United Nations, but Roosevelt informed him that the matter was, quote, embarrassing to the State Department and that, quote, no good could come from such a discussion, end quote. Although Du Bois extensively publicized the petition, providing a copy to the UN to each UN ambassador with a request that the topic be placed before the General Assembly, no UN committees or commissions took action. Next, in December 1951, less than a year after the Genocide Convention went into effect, the Civil Rights Congress, a civil rights organization fighting discrimination in the United States, headed by Paul Robeson and William L. Patterson, presented a 240-page petition entitled We Charge Genocide to the United Nations. We Charge Genocide, one of the very first petitions presented to the United Nations on the subject of genocide, detailed 152 lynchings and 344 other crimes of violence toward African Americans by lynch mobs and by police between 1945 the year the UN was established, in 1951, in addition to thousands of crimes committed prior to 1945. The 1951 petition also emphasized the countless African Americans who died each year as a result of discrimination in healthcare, employment, education, and housing. American representatives at the United Nations, including Eleanor Roosevelt, fiercely argued against the introduction of the 1951 petition, claiming that the United States government was anti-discrimination and anti-segregation, partly to sway the United States to ratify the convention he was lobbying for. The 1951 petition was even dismissed by Lemkin himself. Lemkin portrayed the petition as a maneuver by, quote, communist sympathizers, end quote, to divert attention from the genocide of Soviet subjugated people. Though one scholar noted that "We Charge Genocide" presented America's violence against African Americans in a manner that was so consonant with Lemkin's early writings, in which he presented a more holistic conception of genocide. Other opponents similarly stigmatized the Civil Rights Congress as, quote, disloyal, and the petition as, quote, communist propaganda, end quote. In the face of opposition from the United States and the hostile environment created by the Cold War and the Red Scare, the United Nations refused to accept the 1951 petition. In 1964, Malcolm X and the staff of the Organization of African American Unity drafted a document entitled, quote, Outline for Petition to the United Nations Charging Genocide Against 22 Million Black Americans, end quote, and inquired about procedural mechanisms to bring a genocide case in front of the UN Commission on Human Rights. The 1964 petition charged economic genocide, including the denial of fair housing and jobs, committed against African Americans as illustrative of, quote, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, end quote, and segregation, discrimination, and racial terror as causing, quote, serious mental harm, end quote, to African Americans in violation of Articles 11B and 11C of the Genocide Convention. The 1964 petition further charged police, the Ku Klux Klan, and white citizens councils with targeted killings on the basis of race in violation of Article 2, Section 1 of the Genocide Convention. The 1964 petition asserted that law enforcement and government officials were complicit in these acts of violence and also liable under Article 3's ban on conspiracies and complicity to commit genocide. Malcolm X was assassinated before he could present the 1964 petition to the United Nations, and it was not advanced after his killing. Nearly 60 years later, debate remains over whether the atrocities committed against African Americans fit within the legal framework set forth in the Genocide Convention and Genocide Act. The opponents of charging genocide claim that the specific intent to destroy African Americans required to legally prove genocide is too difficult to establish. This can be unsurprising given the efforts by the United States, given efforts that the United States undertook to bring about a legal framework for genocide that would exclude its own conduct. As one scholar notes, however, the dispute over the requirement of genocidal intent does not negate that the United States, quote, treatment of Black Americans before and after World War II satisfied the actus reus of genocide, end quote, meaning that the results of genocide still occurred regardless of intent. We Charge Genocide is richly supported by disturbing detail concerning the tens of thousands of Black men and women killed for no reason other than their race, the massive mental trauma caused by segregation and other legalized forms of discrimination, and the appalling conditions of life to which Black people were deliberately subjected. While cognizant of the legal definition's mens rea requirement, other scholars have identified the American system of slavery as genocide, pointing out that the institution of slavery and the transatlantic slave trade, by utilizing every genocidal strategy listed in the UN Genocide Convention's definition, inflicted incalculable demographic and social losses. The killing and destruction were clearly intentional, whatever the counter incentives to preserve survivors of the Atlantic Passage for labor exploitation. If an institution is deliberately maintained and expanded by discernible agents, though all are aware of the hecatombs of casualties it is inflicting on a definable human group, then why should this not qualify as genocide? Additionally, enslavers were, quote, very much aware of the outcomes of their activities, demonstrating the intent required by the legal definition of genocide. The traumatization of slaves was practiced, refined, and intentional. How to beat, abuse, torture, publicly humiliate, and terrorize slaves to control and motivate them to obey and work were the basis of endless discussion, exchange, consultation, and advisement among slave masters. End quote. One scholar labeled slavery a multi-generational Holocaust because the damage done by slavery, including abuse and trauma, went on long enough and occurred frequently enough for post-traumatic stress disorder, PTSD, to become intrinsic to African American culture. Outside of the narrow legal frameworks of the United Nations and the United States, academics acknowledge that the cultural destruction, social death, and subjugation of African Americans has resulted in the equivalent of a cultural and social genocide. Furthermore, even scholars who take the very narrow definition of genocide as framed in the Genocide Convention and Genocide Act nonetheless acknowledge that the United States treatment of African Americans can be described as gross crimes against humanity, including persecution, extermination, and apartheid. Regardless of which definition of genocide is used, slavery and the slave trade, murder, kidnapping, rape, torture, or other cruel, inhuman, or degrading treatment or punishment, as well as systematic racial discrimination, atrocities, and harms that have purposefully and collectively been visited upon African Americans are all recognized as, quote, gross violations of international human rights law, quote, end quote, or serious violations of international humanitarian law that warrant reparations. Statutes of limitation. When it comes to reparations, there are no statutes of limitations. When it comes to reparations, there are no statutes of limitations. Quote, where so provided for in an applicable treaty or contained in other international legal obligations, statutes of limitation shall not apply to gross violations of international human rights law and serious violations of international humanitarian law, which constitute crimes under international law, end quote. And that concludes tonight's reading of Chapter 14 of the California Reparations Task Force's final report. Oof. That was a lot. Before you go, if you haven't done so already, don't forget, like this video, hit the bell for reminders, and subscribe to our channel. When you go, don't forget to get connected, follow CJEC on all social media platforms. That's Instagram, TikTok, Facebook, and Twitter at CJEC Official. Get informed by visiting www.cjec-official.org and signing up for current and accurate California reparations news and info on our Get Involved page. And get involved. Support our work by volunteering and or donating. To donate, just click the donate tab on the homepage of our website. Special thanks again to our amazing fiscal sponsor, the California Black Women's Health Project. Thank you all so much for your time. I appreciate you all. We will be back next week, same time, same place, right here on the CJEC YouTube channel with Chapter 15 of the final report of the California Reparations Task Force. We are closer to reparations than we've ever been in California. Thank you and have a fantastic, amazing night.